came across an interesting case there during the week. I just saw it in the Irish Times. I've written a blog post about it. It's to do with psychological or psychiatric injuries, nervous shock injuries in the workplace. It involved a man who was working for the ESB, or at least he was working for a company who was contracted into the ESB, but I think he was working directly for the ESB. But he was out, he's a technician, and he was out dealing with fallen cable, a medium danger or medium height, medium voltage cable apparently, and he didn't suffer any physical injury in the course of this particular incident on a particular day, and he didn't suffer any psychological or psychiatric injury either. But when he went home later, at some point, he realised that he may have suffered an injury. It was possible that he could have suffered an injury, a bad injury. And as a consequence of that, he developed nervous shock or a psychological injury, a psychiatric injury. And so he sued the ESB for the personal injury, basically claiming that the ESB were negligent insofar as they'd given him some machine or some device that was inappropriate or unsuited to the particular task and so on. Now bear in mind all this time that the man hadn't suffered any injury. He had handled the cable in question many times, but he realised later that if he had proceeded on a certain course, then he would have suffered a bad injury. And this appears to be the basis for the psychological injury that beset him later on, and he sued the ESB. The High Court awarded him €83,000. The ESB appealed to the Court of Appeal, and the Court of Appeal issued their decision last week, their determination in the case. And basically the Court of Appeal overturned the High Court decision and said that to grant liability against or find liability against the ESB in this particular circumstance would extend the law in this area of psychological or psychiatric shock to a new level, a level that hadn't been at before, because the High Court held that in order to succeed with a case for psychological or psychiatric injury, there must be a single event which is calamitous and which causes the injury. That was not the case in this particular circumstance. In this situation, unusually, when the man had gone home from work, at some point afterwards, he realised that had he done a certain thing, he would have suffered an injury. I think it's most unusual, an unusual set of circumstances, but I'm surprised that he was successful in the High Court in the first instance. He was awarded €83,000, but as I say, that was overturned by the Court of Appeal, and the Court of Appeal was minded provisionally to award costs for the ESB in both the High Court case and the Court of Appeal case. But the High Court of Appeal decided that to extend the law of liability in this area, the law of negligence in this area, would be a bridge too far, and you'd be basically carving out new ground, new decisions, a new body of decisions based on what might have occurred, and there would be public policy considerations if that was to happen as well. So the Court of Appeal overturned it and awarded costs, or was minded to award costs. I thought it was an unusual case. There's a report there, a blog post rather, on my website, businessandlegal.ie. I hope you find this video useful. If you do, I'd appreciate if you gave it the thumbs up down below. Thanks a lot.